Marriage isn't just rings, promises, and maybe some regret. It also comes with governments acting as the strangest possible third wheel. Across the world, obscure laws turn weddings into something closer to a courtroom sketch than a love story. Some countries ban you from marrying too many times, others tie marriage to military service, and modern digital rules make paperwork stranger than ever. This countdown covers 45 marriage laws that prove bureaucracy and romance rarely mix. And we'll start with a rule that shows even death isn't always the end of the marriage process. Marrying the dead in France. In France, the law allows something both unusual and deeply emotional, marrying someone who has already passed away. This practice, known as posthumous marriage, was originally created to recognize the fiancés of soldiers killed in wartime. Today, it remains available to civilians, but it requires one extraordinary step. You must submit a petition directly to the President of France. The request won't be approved without convincing proof that the marriage was truly intended before death occurred. Letters, legal filings, or documented plans can all serve as evidence. If permission is granted, the wedding is legally recognized and even dated to the day before the partner's death. While it can carry personal meaning, the decision isn't purely symbolic. It affects inheritance rights, survivor benefits, and the legal status of the surviving spouse. This unusual option demonstrates how marriage law sometimes bends to meet grief with bureaucracy instead of compassion. It offers a strange kind of closure, but also raises questions about where the boundaries of marriage truly lie. Yes, under French law you can marry the dead, provided you can persuade the highest office in the country. And if that sounds strange, the next law shows governments also step in when the problem isn't death, but deception. The crime of fake proposals. In South Carolina, a marriage proposal isn't always just a romantic gesture. It can cross into the world of criminal law. Under state statute, making a proposal with no intention of marrying isn't treated like a prank or a harmless joke. It's defined as fraud, and anyone accused could be charged with a misdemeanor. The law was written to target serious emotional deception, like stringing someone along for personal gain, not just casual embarrassment. The odd part is how narrowly it's framed. The rule applies to any man over the age of 16 who proposes to a woman while acting with deceitful intent. If that intent can be shown, the offense falls under a section called Offenses Against Morality and Decency. That alone reveals the lawmaker's stance, that this isn't merely about hurt feelings, but about preserving public ethics. Of course, proving what truly motivated a proposal is nearly impossible. Courts would need to demonstrate intent, which makes prosecutions extremely rare. The statute has less to do with putting people in jail and more to do with signaling how serious the state views fraudulent proposals. Still, the idea stands. In South Carolina, popping the question without meaning it could land you in legal trouble. Ever seen a viral fake proposal video online and wondered if it crossed the line? Drop a comment and let us know. And while South Carolina polices intent, other states write their rules around biology instead. The 65-year-old cousin clause. In Utah, cousin marriage is on the books, but only under very specific conditions. The law blocks first cousins from marrying until both partners reach the age of 65. There's one earlier exception. If both cousins are at least 55 and a court certifies that one or both cannot have children, the marriage is permitted. Outside of those two scenarios, the law remains firm. No license gets issued. The rule isn't built around questions of family tradition or social discomfort. It's explained as a safeguard against genetic risk. Lawmakers designed the age cutoff and infertility exception, so the possibility of children and the concerns tied to that are effectively eliminated. By 65, fertility is statistically negligible. At 55, a court can confirm infertility and close the issue. What makes this clause unusual is how blunt the criteria are. It doesn't rely on complicated genetic testing or case-by-case discretion. It sets two clear thresholds, age or medical certification, and treats them as the end of the discussion. As soon as those boxes are checked, the restriction disappears. This is one of the few marriage laws that hinges almost entirely on biology. But not all states lean on science to set boundaries. Some, instead, draw hard lines based on patterns of behavior. Kentucky's three-strike marriage rule. Kentucky has one of the most unusual limits on marriage in the U.S., a strict three-strike rule. The state allows you to marry, divorce, and remarry the same person up to 3 times, but try for a 4th round and the law shuts the door. At that point, the county clerk is required to deny the license, no matter how heartfelt the reunion may seem. This cutoff doesn't depend on the details of the relationship. It doesn't consider how long you stayed apart, who initiated the divorces, or whether decades have passed since the last attempt. The statute is a hard line. 3 marriages with the same partner are allowed, while a 4th is impossible. It turns a deeply personal decision into a simple tally where the government keeps score and enforces the limit. The state's message is blunt. While reconciliation is tolerated more than once, the law makes it clear that an endless cycle isn't something Kentucky will recognize. Some lawmakers saw fit to frame repeated remarriages not as romantic persistence, but as a harmful pattern. In effect, the state tolerates 2nd and 3rd chances, but declares the 4th one a step too far. How many 2nd chances is too many? That question lingers, especially when, in some places, your biggest obstacle isn't your partner's history, but outside approval that can stop the wedding altogether. Monaco's royal wedding veto. In Monaco, marriage comes with a gatekeeper unlike almost anywhere else, the sovereign prince. For citizens of the tiny principality, no wedding can move forward unless approval is first granted by the royal palace. This requirement isn't symbolic, it functions as real legal authority, and without it, no marriage license is issued. Before approval is given, the law requires your intent to marry to be posted publicly for 10 days. During that short window, objections can be raised, but the ultimate decision rests with the prince himself. If his office files an objection, the process halts immediately, and there's no guaranteed timeline for when, or even if, the block might be lifted. In practice, this system leaves every citizen's personal life subject to direct royal oversight. The origins of the rule date back to an era when subjects, unions were viewed as matters of dynastic security and social control. While most modern states treat marriage as a private choice, Monaco continues to embed it within the framework of sovereign control, preserving a clear reminder of its monarchical tradition. It's hard to ignore the irony. In a world of dating apps and casual breakups, citizens of Monaco still have to clear their relationships with a monarch. And in the next example, other places handle relationship fallout very differently, turning private heartbreak into a courtroom battle. Suing your spouse's lover. In a handful of U.S. states, betrayal doesn't just play out at home, it can head straight into the courthouse. North Carolina is one of the most famous examples where alienation of affection lawsuits are still allowed. These claims let a betrayed spouse sue the person their partner cheated with and demand money for the damage caused. The case doesn't rest entirely on proving an affair happened. Instead, the law asks whether a marriage had genuine affection and whether a third party acted to deliberately interfere with it. That could mean physical infidelity, but it could also cover manipulative actions that undermine the relationship. It shifts the focus from the straying spouse to the outsider accused of causing the breakup. The financial stakes are far from symbolic. Juries have awarded damages that range from 6 figures to millions of dollars, making the price of an affair in North Carolina potentially life-changing. Supporters argue it's a way of holding people accountable for knowingly breaking up marriages, while critics see it as a system that monetizes heartbreak and turns personal pain into a cash award. Either way, it's one of the rare places where love lost in court can come with a dollar amount attached. Would you sue? And while some states attach financial rewards to broken vows, elsewhere, the law interferes in something as simple as choosing a date for the ceremony. Delaware's Sunday wedding ban. In Delaware, weddings can get tripped up not by family drama, but by the calendar itself. A long-standing rule prohibits marriages on Sundays unless couples apply for and receive a waiver. Without that approval, a Sunday ceremony isn't recognized legally. No matter how many guests witness the vows, the marriage remains invalid in the eyes of the state. This restriction comes straight from the remnants of old blue laws, which were built to protect Sunday as a day of rest. Most states scrapped these rules decades ago, but Delaware still enforces this unusual limit. The only way around it is government approval, which means anyone determined to marry on a Sunday has to secure official permission first. For many couples, that extra step is enough to make Saturday the safer choice. The law also provides another odd safeguard tucked into its provisions. If someone says, "I do," as part of a joke or a dare, the state statutes treat that situation seriously. Delaware lists jest or dare as valid grounds for annulment, offering a legal escape hatch for marriages that were never meant to be taken seriously in the first place. And while Delaware focuses on invalidating unserious unions, another state took aim at a different kind of deception, when false promises themselves are written into law as a crime. The crime of seduction in Michigan. In Michigan, a broken promise of marriage isn't just seen as betrayal, it can be treated as a crime. The law still makes it illegal to seduce and debauch an unmarried woman by pretending a wedding is in her future. At its core, the statute targets someone who falsely promises marriage as a way to obtain intimacy. It elevates what might look like a personal wrong into a legal offense. The phrasing may sound archaic, but the intent is straightforward. Using deception to secure a relationship was framed as criminal exploitation. When the law was written, a woman's reputation and chances at future marriage were considered fragile enough that such lies could cause permanent harm. By criminalizing seduction under false pretenses, Michigan sought to cast emotional manipulation as something deserving of state punishment. Prosecutions under this rule are virtually unheard of today, but the statute hasn't disappeared. On paper, it remains a felony-level offense. What was once viewed as moral protection now lingers as a relic, pointing back to a time when the state saw itself as the defender of personal virtue as much as public order. And as unusual as it is to define intimacy through criminal law, in some places, officials went even further, placing medical scrutiny itself at the front door of marriage. Vermont's pre-wedding blood mandate. In Vermont, a marriage license requires more than signatures and witnesses. It begins with blood work. State law still mandates that anyone applying must first take a blood test for syphilis, with results submitted directly to the clerk before the license is issued. Without that signed medical form, the application simply stops, leaving no path forward until the test is complete. What feels like a routine marriage errand turns into a medical appointment that every couple must navigate. This requirement wasn't designed for paperwork's sake. It dates back to the early 20th century, when syphilis was a serious public health threat and legislators saw premarital testing as a way to block transmission and protect future children. Through the mid-century, many states adopted similar rules, but nearly all later discarded them as outdated. Vermont, however, never fully let go of the statute. Today, the rule functions less as a public health safeguard and more as a lingering reminder of how governments once tied personal milestones to medical oversight. Critics argue the mandate adds needless costs and stress for couples, given modern advances in diagnostics and treatment. Yet the law remains in the books, shaping marriage in ways that feel out of step with current healthcare standards. Law and old-time morality do not always update together. And in another corner of America, tradition collides with bureaucracy again, this time where quick weddings are part of the culture, and even spontaneity has to pass through new layers of control. Nevada's digital drive-thru. Nevada has long been the capital of quick weddings, with drive-thru chapels that let couples trade rings in less time than it takes to order lunch. But even those famously fast ceremonies aren't as simple as they once were. In recent years, lawmakers have introduced tighter checks on licenses, ensuring spontaneous nuptials don't slip past basic fraud controls. So while an Elvis impersonator can still officiate from behind a counter, the paperwork now carries more weight than just a hurried signature. Instead of bypassing procedure altogether, couples today face identity confirmations and stricter records before a clerk can issue a license. Some offices use digital systems to reduce fraud, treating marriage documents less like party favors and more like legal contracts tied to databases. The intent is practical, stopping sham marriages, securing records, and making sure split-second decisions meet a paper trail officials trust. Yet the spirit of Nevada's wedding industry hasn't changed. A couple can step off a plane, rent a car, and be newly married the same afternoon, complete with flashing lights and themed chapels. The key difference is that behind the showmanship, every union leaves an official trace that's harder to undo the next morning. That tension between personal impulse and outside oversight sets the stage for other places where marriage isn't just about love at all, but about passing through intricate approval systems before the ceremony even begins. Japan's family gauntlet. Marrying a Japanese national as a foreigner often feels less like planning a wedding and more like navigating a full-scale review. The process isn't confined to two people deciding to build a life together. It overlaps with Japan's household registry system, the Koski asterisk, which anchors family identity to official records. Updating the registry after marriage is straightforward on paper, but in practice, family expectations and cooperation frequently shape how smoothly the process moves forward. Don't be surprised if what you imagined as a quiet ceremony begins to resemble a family board meeting. That influence extends beyond social tension. While Japanese law does not give relatives a formal veto, disapproval can complicate paperwork, delay approvals at local offices, or cast extra scrutiny on the couple. For foreigners, there's also a standard set of additional requirements. Most embassies issue what's known as a certificate of no impediment, confirming that the applicant is legally free to marry. This document, paired with family introductions and background checks, means the process goes well beyond filling out a single form. In many cases, education, employment, and even perceived character come under review. What emerges isn't a simple administrative formality, but an evaluation by both the state and the family structure. The marriage becomes a negotiation of personal choice within collective approval. Some places stop at social and administrative pressure, but elsewhere, the authority to block a marriage is written directly into law. Saudi Arabia's guardian consent. In Saudi Arabia, marriage contracts rest on one signature that carries more weight than any vow, the consent of a male guardian, called a asterisk wali asterisk. Without that approval, the contract is not valid, and the state refuses to recognize the union, no matter the wishes of the couple themselves. A woman cannot finalize her marriage independently. The decision is, by law, incomplete without someone else's authorization. The guardian role usually falls to the father, but if he is unavailable, the responsibility can shift to another close male relative, a brother, an uncle, or even her own son once he reaches adulthood. This arrangement ensures that a woman's marital rights are always mediated through a male figure in her family, regardless of her age or circumstances. Independence, education, or financial standing do not erase this requirement. Saudi Arabia has seen some notable reforms in recent years. Women can now travel abroad, apply for passports, and access many services without seeking daily permission from a guardian. But this system of guardianship over marriage remains unchanged, standing out as one of the few areas where legal progress has not carried over. The contrast is stark. New freedoms coexist alongside a tradition that still gives family authority the final say on marriage. Not every country ties approval to family power, though. In other places, it's bureaucracy and technology that determine whether a wedding counts. India's mandatory digital marriage. In India, weddings have long been defined by rituals, ceremonies, and layers of tradition. But alongside the cultural spectacle, state authorities are steadily pushing couples into the digital realm. Several regions have begun requiring marriages to be logged through online systems, often linked to Aadhaar identification, turning what was once entirely ceremonial into a bureaucratic process managed on a server. Without that entry, a marriage might be recognized socially or religiously, but it lacks the full legal standing the state requires. Officials present the shift as an effort to curb child marriages, reduce fraud, and give women cleaner access to inheritance and property rights. By funneling registrations into centralized databases, marriages become traceable in ways that handwritten ledgers or scattered local records never allowed. The intent is modernization, but the system also ties personal milestones tightly to government technology. For those in cities, the change can feel like another irritating administrative step layered onto wedding planning. But in rural areas where internet access is inconsistent and digital literacy remains low, the online requirement creates real obstacles. A missed upload doesn't just delay paperwork, it can leave a couple legally unrecognized with no clear timeline for correction. The result is a system where even after the vows are exchanged, legal status still depends on successfully navigating data entry. And India is not alone in adding new gatekeepers to marriage. Other countries extend control even further, judging not only paperwork, but the character of those who wish to marry. China's social credit marriage block. In China, marriage isn't just handled through ceremonies and certificates. It can also be affected by the state's broad system of social and administrative monitoring. While the government's social credit framework is most visible in areas like travel restrictions, lending access, or business licensing, reports note that blacklists connected to unpaid debts and other violations sometimes spill over into other bureaucratic processes. In some municipalities, officials have used these records during application reviews, introducing an added layer of scrutiny that can complicate what should be a straightforward step toward marriage. What makes this striking is the way seemingly unrelated behaviors are pulled into the equation. Something like lapsing on a loan or ignoring a fine may have no obvious connection to a couple's relationship, but such issues can trigger flags in the local registry system. Officials can treat these red marks as signs of unreliability, folding everyday personal conduct into decisions about whether or when marriages proceed. The government's stated reasoning follows a consistent theme. People who fail to meet routine obligations are seen as poor candidates for long-term legal commitments. The logic reinforces a model where social order is directly tied to private life choices. Instead of families or communities shaping marriage decisions, digital records and compliance scores become the deciding reference point. This trend shows how administrative oversight can redefine who is considered ready to marry. And while this represents one type of state-imposed filter, other governments take an even harder line, creating legal barriers that erase entire categories of unions once they cross the border. Russia's foreign marriage firewall. In Russia, marriage law comes with a rigid boundary that blocks recognition of same-sex unions performed abroad. A constitutional amendment enacted in 2020 defined marriage strictly as a union between a man and a woman, and that definition now overrides everything else. For foreign couples or Russian citizens married elsewhere, the effect is immediate. The certificate that held legal force at home carries no weight once presented inside Russia. The fallout is extensive. For couples where one partner is Russian and the other a foreign national, marriage normally unlocks rights to residency, spousal visas, and access to family-based immigration. Under Russian law, these doors remain shut. The foreign partner is treated as unrelated, regardless of marital status abroad. The same applies to inheritance. A surviving spouse cannot rely on the automatic transfer of property, even if the two were legally married and jointly recognized under international law. Parental rights also vanish in this framework. A spouse listed as a legal parent overseas may be stripped of recognition if disputes arise in Russia's courts. The law does not just overlook foreign records, it deliberately nullifies them to reinforce a single legal definition. For couples crossing that border, the loss is clear. Protections tied to marriage can dissolve instantly. And while that's a stark example of erasure, in other countries the barrier isn't ideology but bureaucracy itself, where marriage becomes an endurance test of paperwork and patience. Germany's marriage obstacle course. In Germany, marriage starts not with a ceremony but with a careful inspection of documents at the local registry office, the Standesamt. Couples cannot even set a date until officials confirm eligibility. Standard requirements include certified birth certificates, proof of residence, and paperwork confirming neither person is already married. For foreigners, the process expands. They must obtain an *Ehefähigkeitszeugnis*, a certificate of no impediment to marry, which often requires documents validated with apostilles from multiple offices abroad. That step alone can take months to resolve. Once the paperwork is accepted, some states add further conditions. Couples with large age differences or younger partners may be asked to attend advisory sessions where officials explain the legal framework of marriage. Though framed as guidance, it means additional waiting periods before final approval. The emphasis is on certainty. The state wants written proof and demonstrated understanding before granting permission to wed. The entire system is deliberate by design. It prioritizes accuracy over speed, ensuring that every marriage is fully documented and formally acknowledged. Yet this thoroughness has a cost. For many couples, planning a wedding feels tied less to personal choice and more to the pace of state paperwork. Not every country enforces detailed filings. Elsewhere, the biggest challenge to marriage comes from something far simpler: finding people to legally stand by and watch it happen. Australia's Outback wedding witnesses. In Australia, weddings cannot be finalized without two adult witnesses physically present at the ceremony. The law requires both witnesses to be over 18 and to sign the official marriage register on the spot. In cities, this is rarely an issue, since friends and family typically fill those roles. But in remote areas, particularly the Outback, the requirement can turn into a logistical challenge. Couples who set out for a private or isolated ceremony sometimes discover that the law still demands extra hands to make it valid. When faced with this problem, couples often find practical but less than planned solutions. A passing traveler, a local worker, or even staff from a nearby roadhouse has occasionally been asked to step in. The practice isn't about bending rules, but about meeting them under unusual circumstances. Regardless of location, the law applies uniformly. A marriage cannot be registered until two witnesses sign alongside the couple. Unlike some jurisdictions experimenting with online verification, Australia has kept the rules strictly physical. The government insists on in-person signatures as proof of authenticity, even when that means solitude has to give way to strangers. The effect is clear. No matter how remote or spontaneous the ceremony, paperwork cannot be completed without those signatures. That tension between law and lived reality shows how enforcement can clash with lifestyle.